My Lords, I think my learned friend has copies of the submission in question for the bench.
Thank you. Thank you.
Thank you.
Thank you. Yes, it appears in the discussion of burden of proof. Paragraphs 19 and 20.
Yes.
Yeah.
Now, I wasn't going to make any further submission on that. In relation to the approach to non-state actors, there is something of use in the case of Block 61, which is at tab 22, a decision of the Court of Appeal. And at paragraph 57 on page 2028, Lord Justice Auld the other judges agreed, refers to a case of DF and says, as Mr. Justice Crane noted at paragraph 37 in DF, the duty to protect the life of a prisoner against the risk of attacks by fellow prisoners involves different considerations from that owed to persons out in the community and by inference from that owed to a potentially suicidal prisoner. He identified them by reference to the Osman requirements. First, the requirement that the authorities knew or ought to have known of the risk will usually be satisfied much more readily in relation to a prisoner, particularly one who has assisted the authorities, than in relation to a member of the community in general. Secondly, the authorities are in a position to take measures to avoid any risk to an extent much greater than are the police in relation to a member of the community. Thirdly, the authorities are likely to be less inhibited by restraints imposed on the scope of their actions by the need to respect the human rights of others, since providing a protective regime is unlikely to affect the rights of others. And the only other passage that may be of assistance is the one that follows immediately at paragraph 58, quoting again from Mr. Justice Crane, where he says, the word immediate should not be understood in the context of decisions on admission to protective regime to mean that the threat will necessarily materialize in the very near future. That would be appropriate if a particular threat required urgent measures. However, the kind of risk to be assessed in this context is of harm to the prisoner as and when those wishing him harm find an opportunity. Now, with that in mind, I would like to take the court through the majority decision, or the operative parts of the majority decision, beginning, if I may, at paragraph 39 on page MS 138 of the core volume. At paragraph 39 and 40, there are two paragraphs of introduction making essentially 5 points. Firstly, that there is no previous extradition request. Secondly, that there are no international treaties. Thirdly, that little is known of Taiwan prisons. Fourthly, that there is no UK or international monitoring of prison conditions. And fifthly, that there has been a guarded response from the British office in Taipei to requests for information. Then at paragraph 42, the court addresses the issue that it is, it's the task that it's setting out on, and it sets it in a legal context that has not been criticised. At paragraph 42 to 49, the decision deals with the assurances, and it begins with the assumption that Taiwan will make every effort to fulfill the assurances, and secondly, that it is not necessary at paragraph 43 to explore misunderstandings. Then at paragraph 44, it narrates the real risk of Article 3 violation to the appellant, as he was from exposure to the mainstream or the main conditions in Taipei. And I want to read that. I'm satisfied beyond reasonable doubt and corroborated evidence that the main detention building in Taipei prison suffers from gross overcrowding, significant understanding, problems of unchecked and uncontrolled abuse, and bullying of weaker prisoners, inadequate ventilation and toilet facilities, inadequate opportunities for prisoners to exercise in the open air. Further, I am satisfied beyond reasonable doubt and corroborated evidence that the appellant and his past offending behaviour have received such wide adverse publicity in Taiwan that he is at particular risk of being the focus of hostility from prisoners within the prison. It is my opinion, therefore, that were the appellant to be housed in the standard conditions in the main detention building, substantial grounds have been shown for believing that there is a real risk of treatment of the appellant incompatible with Article 3. Now, the point that I want to make is that there are two sentences, or the first two sentences, makes it clear that this is not simply a case of non-state actors. There is a list, if not a litany, of failings in this prison, for which the prison is responsible.
Well, nobody was suggesting that the appellant, or respondent as he now is, would be housed in standard conditions in the main building.
He was to be housed in standard conditions until the undertaking about the separate cell.
We should focus on the points which actually matter in this case. I think you can take it. We've got an understanding of the background, and obviously this is an important starting point, but as my lord points out, it's not what's we're concerned with.
No, but the point I'm making is that the prison conditions which set against which the Article 3 violation is found are matters for which the state is responsible. They are not matters for
but
which...
I think repetition doesn't
well,
prove the point. I think we got that.
Yes, okay. Then at paragraph 45, the only issue is the effectiveness of the assurances and the risk of a treatment incompatible with Article 3. Paragraph 46 implements the assurances and how they will be implemented. And paragraph 47 finds that they would cause significant animosity amongst other prisoners, and 48 contrasts the ordinary conditions with the respondent's special conditions, and observes...
Is paragraph 47, for example, in the first sentence, is that a finding of fact based on evidence, or is it her ladyship's own assessment?
So, 47?
Yes, I'm just wondering, when she expresses the view that about how the prison community would regard the arrangements proposed and so forth.
But it is a finding, in fact, drawn in the context of there being a couple of incidents in which, evidence relating to a couple of incidents in which jealousy of other people's conditions had played a part in prisoner conduct, and combined with Dr. McManus accepting or giving evidence that the 4 prisoners that he interviewed wanted nothing to do with the special conditions. Now, he didn't attribute that, but and indeed the judges divided, because the majority of the judges inferred that this was because it would be disadvantageous to them. These were men who were foreign prisoners who were seen by Dr. McManus. They complained about lying on the floor and being trodden on when somebody went to the lavatory at night, but still wanted nothing to do with the 6-metre square cell that's being offered to the appellant.
But what does that prove about the resentment of the appellant?
It was... The inference that was being made was that the court majority, and not the minority, the court divided on this, drew the inference that essentially they would be afraid to be in these special conditions because of the animosity of the others.
But there's no actual evidence to that effect.
There was a good deal of evidence of this kind. And
I've read the evidence which says that he interviewed 4 people who complained about the cramped conditions in multiple cells.
Yes.
But there's nothing that I recall in that evidence which said, and the reason why they don't want special arrangements is that they would be afraid. One didn't even know whether they'd been offered special arrangements.
It was an inference that the court majority...
Well, the fact that Lord Drummond-Young drew a very different inference suggests that it is a pure inference.
It is an inference, yes, indeed. But that's what...
looking at this,
that's what...
If somebody says, I wouldn't want anything to do with that, why is it to be inferred that somebody who did choose those conditions would be the object of significant animosity? Lord Drummond-Young thought that the only reason prisoners said they didn't want arrangements of this special nature was that they wanted to be part of their prison community as a whole, among their mates.
Well, indeed, but the consequence, if it's right that the special conditions would breed animosity, then...
That's the question.
Yes, the consequence of that would be that you weren't in a position to mix with the rest of the prison. And if you're not in a position to mix with the rest of the prison, you can't go to work. And if you can't go to work, you can't earn parole. So the consequences of it, because you are afraid of the people who are not getting the special condition, keeps you away from them, and keeps you away from earning parole, which can be up to a third of your sentence. But if you don't earn parole in Taiwan, then you don't get it. So the inference that the majority drew was an inference that they were entitled to draw, and simply an issue of fact, which was for them in my submission. And in my submission, it was not only a reasonable, but a very reasonable inference.
There was also, wasn't there, Mr. Bovey, some adverse press comment
There was
about him getting special conditions?
There were two chapters of adverse press comment. There was the fact that the family were recorded as having offered a million Northern Territory dollars
The two press cuttings in question were basically suggesting that he didn't deserve special conditions.
and another
Only
one,
got it because he'd absconded and was being extradited.
and that he didn't deserve special conditions.
That's my point, was that there was adverse comment about him getting special conditions.
Indeed, such that the minister backtracked from the offer in public, and although the court didn't pay any great attention to that in terms of compliance, nonetheless, the political context in which the minister felt obliged to say things clearly spoke to the court.
But I mean, your client wanted, not so much that he wanted the special arrangements, because he wanted to remain in Scotland, but he did not want to be in multi-cell occupation. That was what he was complaining about. And you can't have it both ways, can he? He can't say, well, I object to conditions in Taiwan because of the cramped conditions, and then say, when he's offered uncramped conditions or less cramped ones, well, I object to that because I won't be enjoying the company of the people I'd be sharing the cramped cells with.
Well, the objection to the arrangements that is made is not on the isolation point alone, though, of course, it doesn't follow that
It's not at all, is it? Because your complaint, as I understand it, is these assurances aren't good enough because they might not be honoured.
If you simply because the court they make special arrangements, it doesn't mean that they resolve the Article 3 problems. They may create new problems, and in my submission, that is what has happened here. The issue of the position of the respondent in dealing with the special conditions is that they and the bounty that's been offered create the danger for him, which confine him to the condition, and even if he were safe there, it would not be a reasonable arrangement, because it would be an arrangement that would prevent him from earning parole. And the if one is asking what is the reasonable protection that the court that the authorities have put into place, a position where you require to lengthen your sentence in order to be safe, in my submission, is not reasonable protection, and that is at the heart of what is found here. Now, in relation to 47 conditions would cause, reverting to the majority, at paragraph 50, having dealt with the undertakings and the difficulties that they put the Taiwanese authorities in, then the court deals between paragraph 50 and 58, at the proposition that notwithstanding the undertakings, the appellant or the respondent will still be at risk. And
does the majority deal with the point that you just finished making about the impact of being in the separate building on the ability to work and earn parole?
Yes, it does, my lord.
Where do they do that?
It deals with it at paragraph 53.
Right.
It's line 2 on page MS 143.
Yes, I follow. Thank you.
Yes. Looking then, paragraph 50 is simply introductory. Paragraph 51 sets out issues that are not a non-state actor issues, but issues that relate to the unsatisfactory nature of the conditions. So,
well, they do, but what have they got to do with Article 3?
well, a prison that is overcrowded and understaffed is a prison that it is open to a fact finder to find does not comply with Article 3, my lord.
Necessarily?
No, but we're not in a position.
Has it been addressed as a question of degree?
If I may just
Yes, of course.
answer your lordship's point, we are not in a position of what is necessarily a breach of Article 3. The question for the court is whether it was open to these fact finders to find it. And I certainly don't say that every fact finder would have made the same finding, but I do say that applying firstly, that a violation of Article 3 is a matter of fact, and if I
Well, the standard that Article 3 imposes is not a matter of fact, is it? It's a
No. But a finding as to a violation is a matter of fact.
Such a finding implies two things. First of all, a view being taken about the standard of custody which Article 3 requires, and secondly, a review of the facts to discover whether it complies with that standard. Now, the first of those is a question of law, and the second is a question of fact. I mean, did the High Court examine those questions separately, or did they simply say not compatible with Article 3?
The High Court examines the Article 3 issue in a holistic fashion in the paragraphs to which I have drawn your lordship's attention, and the position in my submission is that they were clearly of the view that, and they had they had evidence of events that had taken place in Taiwanese prisons of the most serious mistreatment of other prisoners and of the of violence against the staff, all of which were publicly blamed and sometimes by the government on overcrowding and management failures. So there was a great deal of evidence about the circumstances, which is in the majority
The attack
decision.
evidence is entirely concerned with people held in the general building, isn't it?
I'm sorry?
The attack evidence that you refer to is entirely concerned with people who were kept in the general building and not in the separate building.
The position was that the Taiwanese, having given a detailed account of how this man would be treated when he was in the general building, which is the one that the Lord Advocate read to you, then withdrew it and selected a cell which had never been used for any purpose. And we see this at paragraph 33 of Lady Peyton's decision. Sorry, they didn't withdraw the earlier undertaking, but they then effectively, 31 on page MS 125, they then produced a cell or a room which had never been used for any purpose, let alone for segregation, And what they then didn't do was to explain how, if this special cell were used, it would fit with the access to the regime that the prisoner needed in order to have exercise, in order to have to earn parole. They wished one assurance upon another. They didn't address how the new assurance would fit with the old assurance. The impression of making it up as you go along was really, I'm afraid, rather strong. So the context in which the court made its decision was not a favourable one to this kind of assurance, or these assurances having credibility, not in the sense that they would not try and do it, but in the sense of their being able to do it. They didn't produce somebody who looked at the whole of the prison. They produced a prison expert who only looked at the cell, essentially, and didn't look at the prison regime, and didn't do a full examination. And they produced a young a Taiwanese professor who had no experience of prisons at all. So if one contrasts this with the case of Dewani, where the a person who was produced and who satisfied the court was a person who actually knew about the prison in question and was able to say, we will be checking this. Nothing of that was done. There is no form of a external checking of the Taiwanese prison that was pointed to. It was all done on a very ad hoc basis. And in my submission, the outcome that we're working our way to is not surprising. Now, if I can take the court back then to the reasons why, between paragraphs 50 and 58, why the court finds that we are still at risk of Article 3 treatment. And the first of these is that the prison is grossly overcrowded and understaffed. Reference is made to the CPT standards, the European standards. Now,
sorry, which paragraph is this?
I'm sorry?
Which paragraph?
I'm at the foot of page MS 142, my lord, in paragraph 51.
Thank you, yes. Right. Yep.
Now, these are the standards that the expert who was flown out to speak to investigate on behalf of the Taiwanese authorities that he used. And the CPT standards have been used by the European Court in relation to extradition to America. I think it's the Ahmad case. And in my submission, it is perfectly possible and appropriate for the court to do that, just as the European Court also uses the European prisoner rules as well.
When you say uses them, what do you mean?
Well, I have in mind a case which I will cut.
If you're coming to it later,
I'll come back to it. But essentially, one of the requirements that they referred to was the need to refer to the European prisoner rules. Now, then moving on from paragraph 51, we have at paragraph 52 in my submission a key finding In the overcrowded and understaffed circumstances currently prevailing in Taipei Prison, I consider it highly doubtful that the prison, even with well-trained and well-motivated staff, has the capacity to be able to provide sufficient protection for the appellant in the context of the large numbers of prisoners who require supervision. And that is the cornerstone in my submission of a substantial, holistic analysis of the situation post-assurances between paragraphs 51 and 58.
Doesn't that postulate a situation which is contrary to the premise in paragraph 45, which is that the undertakings and special arrangements proposed will be fulfilled to the letter? To find then that the authorities don't have the capacity to provide sufficient protection is surely finding that they won't be fulfilled.
No, in my submission, that's not so. They principally, will what they will do, and what I think at 45 is what is meant, is that the undertaking that provides the separate cell will be honoured, and the difficulty with that, but in light of the overcrowding and
Well, I mean, the assurances included a member of staff immediately outside the appellant's cell, clearing the exercise area during any time he was using it, and so on, accompanied by staff during outside exercise,
yes,
et cetera, et cetera. I mean, how is that consistent with the authorities being under such pressure that they couldn't provide sufficient protection?
Well, because the prison is in such a state, essentially.
I know, but it does mean it surely does mean the assurances wouldn't be complied with. That's what.
Yes. Well, it may be that what is meant at 45 is that it is a restatement of the good faith and good intentions of the Taiwan authorities.
Well, that's not what it says. It talks about it being fulfilled to the letter. But a possible explanation, Mr. Bovey, which could reconcile it might be this, that if you read 52 with 53 and 54, her ladyship is expressing doubt whether the Taiwanese authorities can integrate the prisoner with the general life of the prison because of the concerns that you mentioned, overcrowding and short staffing, and therefore, following 52, he might elect to remain full-time in his cell. And then you go on in 54 saying if he were to emerge from his cell, then there would be these problems. So if you read the three together, she seems to be saying there is a danger that this man will have to elect to stay in his cell, yes, with the consequence, as you've mentioned, that he wouldn't earn his parole, etc.
Yes.
Would that be a fair way of reading?
Yeah, no, I think it is exactly right, and indeed, I think your Lordship shortcuts me in that I don't need to take the court further through.
You might need to.
All right.
But in 54, in the second sentence, it tells us that even with an effective full-time escort and so forth, he would, in my opinion, be at significant risk of attack.
Yes.
Obviously, the Lord Advocate says against you, but that's an obvious error in law to view it like that, because you're ignoring the Bagdanovacius approach. You're focusing not on the whether reasonable steps are being taken to protect him, but on whether those steps would actually work.
Yes.
Whereas Lord Advocate says the real question under Article 3 isn't whether there's a significant risk of his being attacked, because prisoners in British prisons may be at significant risk of being attacked, despite all efforts being made to protect them. The issue is, are the Taiwanese authorities going to provide a reasonable measure of protection?
The reasonable, this of course may bring us back to the difficulties of not having focused on Magnum Vicious at the hearing, but the exploration of the effectiveness of the assurance is, in my submission, a legitimate exercise for the court to engage in, and the issue of whether the position of the Taiwanese as to whether what they're doing is reasonable in the circumstances, which is what reasonable protection means, is, in my submission, a holistic one taken either side of these passages 51 to 58, and not at any given point. These are the elements that are that are making up, all of them are making up the issue, and then the question is as to whether what is being done is reasonable. So it is still legitimate for the court to have in mind whether the approach is effective, whether what they're doing is effective or not. And there is nothing, after all, if we look at the issues in Pantia, which is from other Osman cases, the fourth element is whether what had been done would have avoided the risk. So there is nothing in the Bagnanavicius that requires that we should only address the reasonableness, albeit overall the issue of reasonableness is appropriate. My submission is that what is being done is not reasonable, where in order to be secure, the person has to seclude himself, and therefore it's not a segregation according to law, but a self-seclusion, and where the effect of that self-seclusion is to lose the parole prospects. Moving on from...
Can I just ask you before you move on?
Yes, my lord.
Lady Peyton says that solitary confinement is defined as including confinement in a cell with 2 occupants. Is that a definition from the CPT, perhaps? I'm not sure where it comes from.
Yes, I think it is in the CPT.
Right. That's paragraph 53.
That, yes, indeed, that one can be... I mean, the truth is that being the element, I mean, whether it's formally within the solitary confinement, clearly being with one other person only is socially restricting in a way that mixing with a larger number of prisoners isn't, and so that's what the court has taken into account, and that's only a relatively minor point of the presentation that I make to the court.
Well, the CPT, at the end of the paragraph, the last quote in paragraph 53 says the CPT guidance applies equally to situations
Yes.
where someone is accommodated with one or two other prisoners.
Yes, I'm obliged, my lord, yes.
Is that the passage which you're...
I think it is, yes. I think that is the passage that indicates that they also have concerns about such.
It may not be a definition, but the disadvantages that the CPT recognised could apply equally or to a large degree in such...
To a large degree. I think
Yes,
it
thank you.
would be foolish to suggest that being with one other person is necessarily as secluded as being with no other person, but for all one knows, it might be worse. Moving on to 54, then we have the angst, and the fear involved in being at risk of attack. And the court will recall that Article 3 in the prison context is found where the suffering is greater than that inherent in the experience of being jailed. And so the issue canvassed at 54 in my submission is very material to the issue of Article 3. And indeed, the need to be with a full-time personal escort or guard is again essentially an unpleasant experience, albeit the court then goes on to say, well, actually we're not satisfied that there is such a prospect. It doesn't suggest that it isn't necessary. Now, then we come to paragraph 55, which deals with the medical issues. And in my submission, the court has not gone wrong here by dealing with including medical matters in its overall assessment of Article 3. And in that regard, I would draw the court's attention to the fact that in the cases of BB, which is number 3 in the bundle, Ahmed, which is number 35, Kato, which is number 5, Ilash Mawi, which is number 8, and Söring, which is, I don't have the number immediately to hand, but is number 49. In each of these cases, the issue of medical treatment and health were included in Article 3 assessments. And most, if not all of them, I think, are prison cases. And if I can begin then and try and take the court through these.
Well, can we just look at the facts? What is the basis for the conclusion, or for attaching any significance to the conclusion that there are not sufficient, or that I'm not satisfied there are sufficient medical staff and services available? All that Lady Peyton says is such evidence as the court heard suggested otherwise, see paragraph 33. And then when you refer to paragraph 33, the actual report is there seemed to be no great problem for prisoners obtaining medical attention when needed, although the ratio of doctors to prisoner is lower than the CPT standard.
Yes,
have we seen the CPT standards somewhere?
That was only one of the matters considered. There was also at page MS 131, Lady Peyton quotes the prisoner pack as having indicating that you have to pay for
Unless the matters for emergency.
Non-emergency treatment at...
Well, are you saying that every country should have a national health service?
This is what the fact finder found, and the only point of criticism that's been made of it is that it isn't relevant to Article 3, not that the finding was an illegitimate finding. And I'm not sure to what extent this court wants to go into the evidence that was before the High Court and reassess it.
Well, I take the point about the way the case has been presented, but it does seem internally slightly odd, 33 and 55. It's hanging quite a lot along quite a little.
There was also evidence, also quoted at paragraph 33 at MS 129, that overcrowding lowers the quality of life, and in the human rights experts quoted by Lady Peyton at paragraph 38, that overcrowding leads to poor health standards, that it was linked in the Chen article quoted by Lady Peyton at page MS 136, and it was also
This is all about the general position, isn't it?
It is about the general position, and the Control Yuan, which is the Auditor General equivalent in 2010, are quoted at paragraph 38 on page 30 of the appendix as referring to medical and pharmaceutical understaffing. So there was material upon which the court was able to be unsatisfied as to the medical care, and my written submission on this and the other topics is in the bundle. What I say is that when one is considering Article 3, it is not just legitimate, but in fact appropriate for the court to include health as part of an overall consideration of conditions. That if because people who are being attacked and people who are kept in segregation are at risk of physical and mental harm, and the issue of how they will be cared for is of some materiality. And in my submission, it cannot be said that in including this in an Article 3 consideration, the court has gone wrong. I can give the court the pages of the cases to which I make reference. In the BB, at paragraph, BB is tab 3. And at paragraph 8, the accepted evidence in relation to mistreatment, contrary to Article 3, is narrated in 18 subparagraphs, and paragraph 13 is lack of or very tardy medical attention.
Well, there was no evidence of that. On the contrary, we're told that there was seemed to be no great problem obtaining medical attention when needed. Lady Peyton's complaint was that the ratio of doctors to prisoners was below European standards.
If I may, I'm sorry, I'd moved on to the cases.
If Bagdanavicius is, if the Lord Advocate's submissions on Bagdanavicius are correct, we do have to focus, don't we, a little on whether he has made good the proposition that there was no significant complaint about what the Taiwanese government and authorities were able to provide, assuming compliance with the assurances. In other words, there are one or two points where it might be said that the court, the inner house, has been focusing not on risk, but also on inadequacies in Taiwanese authorities, facilities, staffing, and so on. So we might have to look at this area with particular care if the Lord Advocate is right.
Well, indeed, if the Lord Advocate is right that the court is wrong for other reasons, then in its assessment, this court, need not come to the same view on medical treatment as the High Court did. My response has been focused on showing that what the High Court did on medical is not in itself an error, because it was entitled to look at the extent of medical care availability as part of a holistic approach to Article 3. But of course, if the feet are taken from under me by an extraneous matter, which is the hypothesis that my Lord is putting to me, then the hypothesis is correct, yes, that this court need not come to the same view on medical care. I mean, I accept that entirely.
I see the way that's the way you put it. Yes.
Yes. Well, on that basis,
Yes.
I'm happy to move on. In fact, from that issue. Then the issue, paragraph 56, there is no monitoring, and one sees that Othman is referred to, and in my submission, that is an important and legitimate aspect of an Article 3 finding, as is 57, that there is no judicial remedy. So, in other words, the assurances against violation are very limited, because the safeguards are very limited. There is no ombudsman there, or prison monitor. There is no UK monitoring. There is no international monitoring, and there is no established judicial route. And then we come to the conclusion, flagged with this, as her ladyship customarily does, that substantial grounds have been made out for believing that even if the undertakings and special conditions were to be fulfilled, there remains a real risk of treatment of the appellant incompatible with his human rights in terms of Article 3 of the European Convention. And in my submission, what has gone before is a rational a rational analysis, which is one that the court was fully entitled to come to. The de facto segregation in my submission is a matter which makes the appellant's, the respondent's conditions in prison not according to law. He isn't the subject of an order, and the
Sorry, what did you say? Is de facto segregation makes his detention not according to law?
makes his conditions not according to law. Yes.
So in what sense?
Well,
Which article are we on now, Mr. Munro?
I'm sorry.
Which article are we on now?
We're on Article 3 still.
Are we?
Yes.
Right.
I don't want to distract you. I just want to understand what point you're making by saying that.
In order to avoid arbitrariness, segregation must be governed by procedural safeguards and only used exceptionally after every precaution has been taken,
I see.
and must have judicial supervision. And the European Court...
Are you talking about punitive
No,
arrangements? Or?
not only. But my Lord beats me to the point, which is that the European Court, and I'm looking at the Ahmad case, the European Court pays particular attention to segregation of prisoners who are not dangerous or disorderly. So these...
Where is the Ahmed case?
The Ahmed case is tab 35, my Lord, and I'm looking at tab 35. I'm looking at paragraphs 211 and 212.
Thank you.
And this, we're looking at the general principles and at paragraph 202, we see for a violation of Article 3 to arise from an applicant's conditions of detention, the suffering and humiliation must go beyond that inevitable element of suffering or humiliation connected with a given form of legitimate treatment or punishment. That was the expression I was trying to recall.
What is the argument? The argument is that he could mingle, but he would feel unsafe, and therefore he would end up effectively confining himself to his room, with whoever who was his roommate.
Yes, except that I think it go further than that. He could mingle, but he would be unsafe. I think the findings of the court justify me in...
He would be unsafe out. He would therefore self-confine himself, which you say is to be equated with this sort of solitary confinement
yes.
being talked about here.
If I may just read 202, because it covers the health point to some extent at the end of that paragraph. Measures depriving a person of his liberty may often involve an element of suffering or humiliation. However, the state must ensure that a person is detained under conditions which are compatible with respect for his human dignity, that the manner and method of the execution of the measures do not subject himself to distress or hardship exceeding the unavoidable level of suffering inherent in detention, and that given the practical demands of imprisonment, his health and well-being are adequately secured. And of course that takes me back to the health point we talked about a moment ago. When assessing conditions of detention, account has to be taken of the cumulative effect of these conditions. And at
the length of the period during which a person is detained is also to be considered. But he's going back, on the present sentence for a maximum of a year, subject to parole.
Indeed, he would, if he was...
Which is 1/3. So on the face of it,
if he got parole 8 months, but you say that he might not get parole because he'd be in solitary confinement.
Yes, indeed. Yes. The fact that he has served the time which, if he'd been serving it as a Scottish sentence or he'd been serving in a...
I think that's a later point. You'll be coming on to that.
Well, it goes to the proportionality of what is being done here.
Right, all right, well, now, so those are the statements when we're talking about presumably sentencing to solitary confinement, are we?
If we look at 208, my Lord, at the same time, the court has found that prohibition of contact with other prisoners for security, disciplinary or protective reasons does not in itself amount to inhuman treatment or punishment. In many states, parties to the convention, more stringent security measures which are intended to prevent the risk of escape, attack or disturbance of the prison community exist for dangerous prisoners.
Am I right? Ahmad was a terrorist suspect who the contest was about extradition to the United States.
Yes.
He had a series of complaints about what might happen to him there, one of which was that he'd be at risk of being confined in solitary confinement compulsorily.
Yes, yes.
Got it.
Yes.
It was certain he was going to be.
Sorry?
He was going to be incarcerated
Yes.
in the maximum security
Yes.
Yes.
jail in which everybody was effectively in solitary confinement.
What was at stake for him in terms of prison and what he was accused of were entirely different from the present case. Absolutely.
This court considered Ahmad and all these issues in the Shahid case quite recently in relation to a child murderer
Yes.
who, for his own protection,
Yes.
was in solitary confinement for almost 5 years.
And that was before the High Court, because Lady Payton refers to Shahid in her judgment.
Yes, indeed.
And she refers to it for the points that this court made about the gravity of solitary confinement and the potential consequences.
Yes.
But at the same time, at the end of the day, the court held that there had been no breach of Article 3 in that case.
Yes. Yes. In my submission, however, again, he was a child murderer, as your Lordship says. This man has a 4-year sentence for which he has served more than 2/3, 3/4, and is going back for a problematic situation. And that the context in which we find ourselves is so wholly different from the cases in which solitary confinement has been found proportionate, that in my submission, the issue of what constitutes Article 3 was properly approached by the court in that context.
I mean, it's incredibly fact-specific, isn't it? If you look at the paragraph 209 and 210 and 211, and also if you look at Shahid.
Well, I hear what your Lordship says, though I do see that we're in a section beginning at page MS 2374 on the general principles, and it was 211 and 212 that I was planning to take the court to support the propositions that I had made about the fact that of the need to avoid arbitrariness in solitary confinement by having procedural safeguards that safeguard the welfare and proportionality of the measure, and the exceptional nature of the remedy. And indeed, this is where the European prison rules to which I made reference are referred to at the top of page 2376, and that was the reference that I was unable to give Lord Hodge a few minutes ago. But it is where the court is applying, although Ahmed is going to the United States, the European Court does apply the European prison rules.
Well, it doesn't apply them because it has itself said that one is not required to effectively police the standards of custody in countries not party to the convention.
Well, I understand what your lordship says. What it says is every precaution has been taken as specified in paragraph 53.1 of the European Prison Rules.
Well, this is part of the evidence that it's summarising.
The approach to the issue of segregation is that arbitrariness is to be avoided. My submission is that at paragraph 35 in Ahmed.
Much longer period.
No, I'm sorry, paragraph 178, I do apologise.
178.
178.
Sorry, 178 in...
178 at paragraph, page MS 2368. In the context of each ill treatment of prisoners, the following factors, among others, have been decisive in the court's conclusion there's been a violation of Article 3. And one of them, and accept the applicability to the present situation is quite limited, but one of them is the arbitrary punitive nature of the measure.
Is that not dealing with a situation where solitary confinement is imposed as a punishment?
Yes.
It may be, yes. It may be that it's something that I don't need to establish. But I do, in fact, wish to submit that the regime that is the respondent is being sent back to is arbitrarily punitive.
Now, Mr. Bovey, you're moving on towards the end of your allotted time.
Yes,
You
and I have things to do. Yes, I will.
10 minutes, and you should deal with all the points you need to.
Yes, I'm obliged. Simply to say on the arbitrarily punitive that it, in circumstances where he has already, in my submission, served the sentence in substance, which result, that the circumstances result from the Taiwan state prison regime, particularly overcrowding and understaffing, and where the outcome prevents him from earning parole to which he is entitled in the sense of being entitled to work for it, the outcome is arbitrarily punitive, albeit I accept what my Lord Reid says, that that isn't a requirement for a person who is in protective solitary. What I do say is that it causes more hardship than is inherent in legitimate imprisonment, and that the outcome of the decision of the High Court was, for these reasons, a wholly appropriate one. if I may turn to the other two arguments in relation to the proportionality argument. We see that the prisoner, the respondent, had served 2/3 of the sentence on the 17th of June of 2016 and was released on the 23rd of September, some 3 months later, and that we have a letter from the Taiwanese saying that he will be released if he goes in June of last year, in September of this year. In the circumstances which are before the court, in my submission to extradite involves both Article 8 and Article 5. And the circumstances in which Article 8 is in play are set out at paragraph 44 of my case at page MS 93. And they include his being a United Kingdom citizen, brought up and educated in Scotland, albeit he's lived for some years in Taiwan. He still has connections here, and it was to Scotland that he returned on his departure from Taiwan. The issue of the outstanding request in my submission should not play a part in this court's consideration, not least because the memorandum of understanding between Taiwan and the United Kingdom is only in relation to serving sentences, and the current request is in relation to for wanting for trial, and therefore the Taiwanese are some distance away from securing the respondent on that current request.
Can you just tell me in a sentence or two how the fact that he's a United Kingdom citizen weighs in the exercise that you're currently asking us to undertake?
It in my submission, it weighs because a United Kingdom citizen has a legal entitlement to live in the United Kingdom.
That's not the same thing as his private or family life, is it?
No, but it secures him here. If he were a foreign citizen, then his right to live here would have to be established by a different route. Some foreign citizens do have that right, but not all of them.
But if he were being extradited, we'd be on the question of what was going to happen to him when he got to the other end, not what his rights are here, wouldn't we?
Well, no, because what we're saying is the fact of extradition is an interference. I mean, it's being taken from here to there.
Well, yes, it is.
That is what's complained of, not his treatment not just his treatment in Taiwan.
Yes, but it doesn't get any worse just because you have the nationality of the United Kingdom, does it? The question is what real roots you have here, isn't it?
The roots are obviously important, but the fact that they're legal roots rather than de facto roots is in my submission, also important.
But surely it's absolutely clear from cases starting with Söring that the objection is not to the removal from a country where you are a citizen. The objection is entirely to the treatment that you will receive when you get to the destination.
That is true, except
Extradition itself is perfectly consistent.
Söring was a German, and the proportionality argument there was that there was trial available in Germany rather than anything that he had here.
I think he was resident in the United Kingdom.
He was resident of the United Kingdom, but he wasn't a British citizen, and he. So, in my submission, the Söring is useful in the sense that it is a clear indication of proportionality applied both in Article 3 for the argument we've just done and generally.
So there's a greater interference if you extradite a British citizen than there is if you extradite, shall we say, an Australian.
In my submission, there is, because he has legal roots here.
Yeah. Yep. I mean, in extradition, despite the extradition of Mr. Norris, there are cases in which we've refused to extradite people because of their family links, their links with children in this jurisdiction. So yes. I suppose that's where you're building from.
Yes, yes.
All right, well, we've got the point, and how much citizenship adds is a debatable question.
I don't add it except as a factor.
But I mean, can he really complain? Has he got any roots, the disturbance of which he's entitled to complain about? He was actually based in Taiwan for most of the time, and he fled from Taiwan. He fled justice.
The principle is, if the point is that the extradition, where one has served the sentence and where one won't be able to earn parole, is disproportionate. Really, having roots here is simply a feature of it. It's not the heart of it. He doesn't have the kind of roots here that one would rely on in an article case simpliciter.
Why is he entitled to the British rules about parole? He's committed an offence in Taiwan. He chose to flee from Taiwan. It assumes that people know what the law is. He must have realised that if he was caught, time spent resisting, he could, of course, have agreed to go back to Taiwan straight away, in which case the problem wouldn't have arisen. But he hasn't. He's resisted it. That's his right. If he's ordered to go back, it's entirely his own fault that he's lost the parole.
I take my Lord's points. He's not entitled to the British parole, and that's put in as an illustration. It's not relied upon. The Taiwanese parole, in my submission, is of more moment. It was
he could have got the benefit of the Taiwanese parole by not resisting these extradition proceedings.
He could have.
It's his choice.
He was allowed. I mean, the December 2013 assurance that he would have his...
Right, so you say the assurances came late and he was entitled to resist?
Well, it said that he would have the deducted day for day, and it was only 2 years later when Dr. McManus went out that it emerged that actually it wouldn't count for parole and he would still have to do the 2/3 of what remained.
Well, that is your point in relation to Article 5, because your Article 5 point is simply arbitrariness.
Yes.
And in effect, you're accusing the Taiwanese authorities of bad faith. Is that right?
No, I wouldn't wish to do that.
Paragraph 52.
You talk about deception and bad faith.
An element of deception and bad faith on the part of the authorities is what you...
Yes.
I mean, that's pitching it pretty high. I mean, for what may have been a misunderstanding as to what day-to-day meant.
That was intended to be a statement of the law rather than an accusation against the Taiwanese.
But absent such bad faith and deception, where is the arbitrariness?
The issue the arbitrariness is in the circumstances that I have narrated, and the fact that the undertaking of 2013 did give the impression and that time would be deducted in essentially an effective manner, whereas it has been deducted in a much less effective manner. Now, that is just something that has happened. I don't think I need to say that that is bad faith on the part of the Taiwanese, but it is
Can you exclude a misunderstanding?
I can't exclude anything except that when they give an undertaking that doesn't mean what it appears to mean, then it is unfair to the person who reasonably proceeds on the basis that he should lose out by it.
Well, hang on, he hasn't reasonably proceeded on any basis, has he? He simply clung on here as long as he possibly could. And how long has he now served of his 4-year sentence in Scotland?
3 years.
Which isn't bad going, is it?
Well, I mean, it means he hasn't got off with it. He's served 3 years, which is a long time on any view.
I see.
Let me just tie down. He was in custody roughly for 3 years until June 2016.
No, September.
Until September 2016.
Yes. 23rd September.
During that period, part of the time, there weren't any undertakings, or there were some undertakings.
There was an undertaking that he would be he would benefit, or that he.
There was the December undertaking 2013 about deduction.
Yes.
And then there were undertakings about conditions in February 2014.
Dr. McManus addressed this issue at his report, beginning page 671 of the appendix, and on page 678 we see the grading system and remission and parole. And at page 685 we see the undertaking from 23rd December 2013.
685.
685, yes. Okay. 685 is the undertaking. And then once you've read that, if I may take you back to page 678. And page 678 sets out the circumstances, and at the foot, having set out the rules, he says, it's understood that Mr. Dean is classed as a recidivist and will thus be required to serve 2/3 of his sentence before parole consideration can take place. The question arises, however, about whether and how account can be taken of his time in prison in Scotland for the allocation of grade points to enable him to achieve grade 2 as soon as possible and gain remission in case parole is not granted. The authorities have indicated they will consider the time served in Edinburgh as part of his sentence. A way should now be found to ensure that Mr. Dean's behaviour while in Edinburgh can be assessed in relation to the grade point system.
So when did the contrary become clear?
When he reported in 31st August 2015.
So is we need to distinguish, do we, Mr. Munro, between parole and remission. Is parole discretionary?
No, I don't think any of it is discretion. What we have, as we understand the system now, and I don't think I understood it from Dr. McManus's
if we don't know, we don't know.
account, is that the 3 years that he served will, in terms of the undertaking that we've just looked at, be deducted, but that will leave him with a year to serve. Yeah. And his good behaviour in Edinburgh, which would have earned him parole in the Scottish system, doesn't count for
It clearly doesn't, but there's nothing in page 685 in the undertaking that the Taiwanese authorities gave which remotely suggested that it would. I mean, all that it says is all periods of detention will be deducted from the total period of detention, and they're honouring that.
Indeed. It was only
Mr.
when...
McManus, really? It's Mr. McManus's interpretation that might be read to the contrary.
But Mr. McManus says something will have to be... The authorities have indicated that they will consider the time served as part of the sentence, and he then says, not attributing anything to the authorities, a way should now be found to ensure that the behaviour can be taken into account.
Well, he's rather assuming that you can earn parole in Edinburgh.
He may be assuming that, but I don't see that indicates any arbitrariness on the part of the Taiwanese.
I think we've got to watch the time a
absolutely.
little more closely.
That's the second argument, and the third issue is also set out in my case, this time at page memory stick 96, and in that regard I draw the Court's attention to the fact that Lord Hope, in the Mills case, tab 18, paragraph 34, memory stick, page 1948, said that the Court's jurisdiction, devolution jurisdiction, was not confined to answering the devolution issue, but extended to any other matter reasonably incidental to the determination. And I simply indicate that the power of the Court in regard to this case goes well beyond what is necessary to decide the legal issues.
In other words, if we felt it was unfair, we could, as a matter of general principles of justice, simply say don't extradite?
Yes. Unless there's any matter with which I can assist the Court, I'm very much obliged.
Thank you very much. Mr. Brown?
Nothing to add beyond the submissions of my Lord and Senior.
Thank you. Mr. Lord Advocate.
Yes, thank you, my Lord. I wonder if I could just make one or two brief remarks, particularly on the parole issue. If I understand the position correctly, parole in Taiwan is neither discretionary nor automatic, in the sense that a particular period of time served leads to automatic release. There is a letter from the relevant authorities, which is at pages 660 and following.
Page?
660 and following of Volume 2, my Lord, which describes the system of parole. In effect, if I understand it correctly, the inmate requires to earn points, the starting point being that a minimum relevant period has been served. And the difficulty that has been identified is that in the domestic law of Taiwan, the minimum period is calculated by reference to the period spent within the Taiwanese prison system. The respondent's complaint in relation to parole, and it also formed part of his Article 3 complaint, was that if he, is twofold. One is that by reason of where he finds himself, if he were to be returned to Taiwan, his ability to qualify for parole would be affected. But secondly, that if he, in the context of the prison system in Taiwan, he chose to segregate himself from other activities, that would equally affect his ability to earn parole. And he relies on various articles 3, 5, and 8. Perhaps I can make this submission, my lords. The Convention doesn't require us to expect of a foreign system that it should have any system of parole. Were it to be the case that the Taiwanese system did not provide for parole at all, then that would not add to the Article 3 case. It wouldn't render extradition Article 5 non-compliant. And in the context of this respondent, applying the principles in Norris, it wouldn't come anywhere near a breach of Article 8 in my submission. I can refer to two authorities effectively for the proposition that it's not for us through the medium of convention rights to impose a particular sentencing regime on a foreign state. The two cases are Chalinsky at tab 19, paragraph 13, MS 1963, and Wilcox, tab 32, paragraph 74 at MS 2258. And I return on this point to the observations I made in my principal submission that insofar as there is an impact on the way that the Taiwanese domestic law would be applied to this respondent were he returned, that is simply a consequence of the domestic law of the requesting territory, coupled with the fact that the respondent has been a fugitive from justice. So far as the main point is concerned, I don't think, unless the court has any issues that it wishes to raise with me, I don't think there's anything further that I would wish to add, save to just make these points. First of all, as I observed in my opening, I acknowledge the findings of the court, and I acknowledge the evidence upon which the risk to the respondent is based. The question remains whether the undertakings are a reasonable provide a reasonable response to that. The undertaking at MS 63 offers to, or states that the authorities will assess the risk. If required, they will take steps to separate the respondent from.
Do you have another reference for that besides MS numbers? We don't have them on a lot of the documents.
But we certainly have that undertaking in the.
Well, MS 63
it's simply where
a reference to your case.
It's a convenient.
Oh, fine.
It's a convenient point at which that is noted. If the real risk is at the level apprehended, requires the segregation of the respondent, then there is the commitment that the authorities have given to address that.
We do have to consider, don't we? I put this to Mr. Bovey. If you're right about Bagdana Vicious, then we do have to consider not merely the sufficiency of the undertakings, but also whether there were any respects outside the scope of the undertakings in which it could be said that the Taiwanese authorities would fail to take reasonable precautions with regard to the findings.
Indeed. I mean, my submission is that the risk that's apprehended and spoken to in the majority of the appeal court is a risk of violence from other prisoners, not when the respondent is in his cell, but if he is mixing within with other prisoners in the mainstream. And I've pointed to the assurance given on 25th of February 2014 as setting out the steps that the respondents...
You say that insofar as they lead to the conclusion that he might have to withdraw to solitude, that's not itself a breach.
That's not itself a breach.
But in those circumstances, he wouldn't need medical attention and things like that.
Well, indeed. I mean, I recognise that in the generality, the availability of medical facilities might form part of an overall assessment of prison conditions.
But here it's linked to the violence. And
here we're on a very specific question, leaving aside the particular points that has been made about medical condition, medical provision. And insofar as either a compulsory or voluntary segregation were to have an impact on the respondent's ability to earn parole, again, I say that's simply a matter for the domestic law of Taiwan, and it doesn't create an Article 3, Article 5, or Article 8 breach. And perhaps the one final thing to say about parole is, of course, parole may be a release from detention. It isn't the end of a sentence. That's certainly true in our law. And although I'll be correct if I'm wrong, I don't think there was specific evidence before in the oral procedure in the court below at 1079 and 1080 in volume 3 of the appendix, where one finds the laws and regulations, or some extracts from the laws and regulations of Taiwan, the Prison Act. It appears that an inmate who is conditionally released, said, should obey the regulations of probation during the period of parole. In other words, parole, if I am reading that correctly.
Sorry, which page are we on?
It's 1079 of volume 3. If I'm reading that correctly, that as in our system, parole is not the end of the sentence.
Yeah.
So, but the basic point is that's all a matter for the domestic law of Taiwan. Doesn't advance, in my submission, the respondent's position here. So unless I can assist the court further, I'm content to leave matters there.
Yeah, thank you very much indeed. The court's grateful for the submissions of counsel and will take time to consider what judgment it will issue in the usual way. Very much indeed.